Hello, everyone. Welcome back to SEC Roundup. My name is Tom Zucchero. I'm a partner in the Investigations and White Collar Group at Paul Hastings. With me, as always, is Nick Morgan, also a partner at Paul Hastings. Hi, Nick.
Hey, Tom.
And we're honored to have join us today for this episode our new superstar partner from New York, Avi Weitzman, who's in our White Collar and our Complex Litigation practice groups. Avi, how are you?
Good to be here, Tom and Nick.
Well, we're going to talk today about ephemeral messaging, text messages that many of our kids use where their text disappears after a certain time or is encrypted, like WhatsApp or Signal. Not an issue in high school, but a big issue in investment advisory world. At the end of September, the SEC and the CFTC brought an enforcement action against a number of firms for using ephemeral messaging apps like WhatsApp to send client text messages and other business-related communications. So, Nick, let's start with you, and maybe you can give us a little background on what those cases and what the concern is from the SEC and CFTC.
Thanks, Tom. Yeah, I'll let Avi talk about the recent cases and just sort of setting the table a little bit. This topic of electronic communications generally, of which ephemeral messages are a subset, has long been of interest to the SEC and other regulators. And even as to the ephemeral messaging point, that's not a new thing. Like these enforcement actions that were announced have, as I said, been a long time coming. The SEC's OC, the office formerly known as OC, has put out risk alerts. The Director of Enforcement has talked about ephemeral messaging in speeches. So there's been the usual signaling that usually precedes enforcement actions that has occurred on this topic. And as we saw by the CFTC joining in this most recent announcement, other agencies have an interest in this topic as well for different reasons. DOJ, CFTC, FTC, and others. So this is a topic that, to the extent we weren't paying close attention before, I think the recent announcements have caused us and our clients to sit up and pay maybe more attention to the topic.
I mean, maybe you can talk a little bit about the cases. The penalty amounts were staggering in the billions of dollars. Tell us a little bit about the cases and why this is such a big concern to the regulators.
Yeah, you're right. The penalty amounts were staggering. It was late September, and the SEC and CFTC announced about the same time settlements with 16 financial institutions, Wall Street banks, all the largest banks that you would have heard of. And the penalty amount for all 16 together collectively was $1.8 billion. That means that many of the banks paid between $100 and $200 million each. To put it in perspective, in fiscal year 2022, the SEC just announced that they had total disgorgement and penalties of approximately $5 billion. So $1.8 billion compared to the entire disgorgement of the SEC is about 35%. That's a huge number for the SEC to collect. And what's important here is that this wasn't a grave sin of fraud. That's when you think of, the largest penalties, when consumers, customers, investors are being defrauded out of assets here. We're talking about what was fundamentally a books and records violation. And the exact same things that the banks were doing, we all do on a day-to-day basis. We're all texting our clients. We're all doing WhatsApp. Hey, can you meet? The SEC regulators, the US Attorney's Office, the CFTC staff, they're doing the very same thing. And so technology has gotten ahead of the regulations, and the regulations are now catching up by forcing the banks to rein in the use of this technology, the same technology we all see. And so the problem, as the SEC and CFTC saw it, is that they labeled this off-channel communications. These were communications that investment bankers and traders had at Wall Street banks with clients, customers, and coworkers regarding what they deemed to be investment strategies, client meetings, market analysis, and market activity. It could be innocuous text messages like, did you see what happened with that company or that stock? Not at all fraudulent in nature. And why was this a problem? It was a problem because the regulations that govern regulated industries like financial institutions, the SEC and CFTC, have books and records requirements, and they require the banks to maintain all work-related communications on their systems. And so when these investment bankers were having communications with clients and colleagues about various innocuous things, or what could be just innocuous things, the banks couldn't retain them. As they're called, they're ephemeral messages. Text messages exist, they don't disappear, but they could be deleted. They could be destroyed for any number of legitimate reasons. WhatsApp messages could be deleted or destroyed. There's Snapchat, and there's lots of other different messaging applications that the banks can't retain. And when the banks when there's an examination or an investigation, sometimes those messages aren't around. No fraudulent intent here, no desire necessarily to delete this messages in order to destroy evidence, but it inhibits, in the SEC and CFTC's mind, their powers of investigation. And so they hit the banks hard with some of the largest penalties we've seen in quite some time. So let me tell you a few other things that are notable besides the fact that these are not fraudulent messages and there was no allegation of fraud. Typically, the SEC and CFTC resolves cases, as you all know, with a neither admit nor deny settlement. These were not neither admit nor deny. They forced the financial institutions to all acknowledge the conduct and the violations of the books and record statutes. That could have significant impacts if they're repeat offenders and they don't get their house in order. They've also required that all these 16 financial institutions hire what they called compliance consultants. This isn't exactly a monitor, but it's not that different. These are people who the banks have to hire and provide periodic reports to the SEC and CFTC about each firm's implementation of compliance enhancements. The third thing, this isn't the last we're going to hear about this. This is the shot across the bow, so to speak. It started with financial institutions, but there are other regulated industries under the SEC and CFTC's books and records requirements. You have trading firms, you have investment advisors, you have hedge funds, you have private equity funds. It is entirely likely that all those other regulated industries are now going to feel the same heat about getting controls and compliance around ephemeral messages and text messages and so on. And so all these other regulated businesses and industries have to avoid regulatory scrutiny, and they can do that any number of ways, but it has to be done. Just earlier this week on November 30th, there's a Washington, D.C. FCPA conference, and SEC and DOJ officials speaking at the conference noted that this is something that they are keenly aware of and looking at, and that it's important for all companies, not just regulated industries. The DOJ is saying all companies now need to start thinking about how to regulate the use of ephemeral messages for business purposes. So how should the companies fix this when technology is so ubiquitous and we all do exactly what the SEC and CFTC are saying is a violation of regulations? Well, the first thing they need to do is they need to get their compliance policies in order. They need to either prohibit or limit or regulate in some way the use of text messaging for work-related purposes. They have to, and when you get the compliance policies in order, you then have to implement them and you have to enforce them. You have to have periodic training. You have to make sure that you can audit or capture the use, identify the violations, and then you have to have teeth for punishing violators, whether it's suspensions, additional training, or even termination. It may well happen that that when there are future violations, it will be a terminable offense at Wall Street banks. The regulators are keenly looking at how you enforce these policies. There are other things that financial institutions and other companies need to consider doing. Do you have a BYOD policy, bring your own device, which causes often employees to use text messages on their own devices to communicate with customers or colleagues? Or do you provide your own work phone from the institution and firm that can be more easily monitored and supervised. Or maybe you have certain programs that you require your employees to download that is a monitored, supervised use of IM. As Slack, for example, like you have on your work computer, you can have similar programs on your phones. And then, of course, you need to consider auditing and monitoring, doing periodic tests of your employees and seeing what types of devices they have. Now, that's a sensitive issue because there are privacy concerns, particularly for firms in Europe that are governed by the GDPR. You have to be careful about how you deal with that. And so it's very important that you understand the privacy laws at the same time that you try to comply with US law. So firms are in a catch-22 here. Either they can either go too far in the extreme and violate employee privacy, or they are too lax and they violate books and records requirements. But they've got to do their best to have a comfortable medium where they comply with the books and records requirements.
Avi, from your comments, it sounds like this could just be the beginning, and we may see more cases involving other industries.
Yeah, I think this is just the beginning. I think you're going to see the SEC and CFTC periodically examine firms for these violations. And I think with this shot across the bow, I think the penalties could be even larger the next time around, because now everybody's been forewarned. Yeah. Everybody knows that this is something that they have to get their house in order, and this is something that is going to be examined. And if they don't adopt the policies, or if they adopt the policies but don't strictly enforce them, the SEC and CFTC might be looking to make an example of you.
Yeah. Well, Avi, those are great insights. Thank you so much for joining us today. Nick, thank you. And we'll see everyone back at the next SEC Roundup.